So good morning, everybody. So you did say many of you have state operations in multiple states. How many have employees in Massachusetts? Okay, and Maine? Okay, so some. Those and New Hampshire, obviously. That's where I'm going to spend most of my time because that's what we deal with most is in those three states. But I have done this presentation before looking at many other states. So to the extent that I can grab a couple of other states and just alert you to the fact that you may want to be paying attention if, for example, you're looking to acquire a company in Connecticut, there's some things that you're going to want to pay attention to, but I'm not going to go into as much detail in those states. So I'll be talking about managing and complying with state leave laws. Jim did mention federal, and I'm not going to go into the federal today, other than a brief mention of the FMLA, just because it's so changeable, and we have no idea how that would affect the various states. So states is where it's at for this morning, and I'm going to just go through some of the key leave laws. Sick time, sorry, let me catch up to myself here. So paid sick, parental leave, and family and medical leave. Obviously, there are many more. There's some states have domestic violence leave. There's obviously military leave. There's a number of other types of leave, but I'm going to stick to these three just because there's a lot of depth with each of them. Talk about some recent developments in New Hampshire, Massachusetts, and Maine, and a preview of some things that could be happening in those states. And then get into managing leave policies. So first with sick leave, just to give you some, make sure we're all on the sort of the same footing of what types of programs are out there and what is mandated by state law. So typically, sick leave plans or sick leave requirements in various states have some basic purposes. Some states have a little bit, have some nuances to this, but it's usually now not just for the employee's own health, but it's also for their, not just calling in sick, but also preventive care. So if an employee has some sort of health condition, being able to go to the doctor for preventive care, even if they're not experiencing any symptoms. Then their family members' health conditions and preventive care. So that's a pretty standard thing that we're seeing now. It's not just I'm calling in sick, but I have to take my mother-in-law to the podiatrist. So it's non-emergent and she's a parent of a spouse, but there are states that are including that range of purposes within their sick leave laws. And then some states also say that sick time can be used for various domestic violence purposes. So not only to get physical, treatment for your physical injury caused by domestic violence, but also maybe to meet with a counselor or to get housing, that sort of thing. So there are some states that include domestic violence purposes within their sick leave laws. The sick leave laws that we've been seeing coming down, they're not cookie cutter by any means, but they do have some common elements. So they do talk about what type of notice does an employer have to give about an employee's rights? How do they do that? In handbooks and posters? What do they have to tell their employees? And then employees have notice requirements. How much time advance notice do they need to give if they're taking sick time? It's not just calling in sick that day, but for example, in Massachusetts, you can require them to give 7 days notice of a planned medical treatment. Now, they may know about that treatment 3 months ahead of time, but Massachusetts says they only need to give 7 days notice. So the notice requirements are going to be important to know about as an employer managing maybe multiple workforces. What do you have to be telling people, and what can you require of your employees in terms of notice? The rate of accrual is really important. States have various rates. And just to give you a glimpse of what types of accrual rates we're seeing, a couple of slides later, Arizona, 1 hour for every 30 hours worked. California, the same. Connecticut, though, it's 1 hour for every 40 hours worked. So there is a little bit of variety. In what we're seeing, Vermont being the least generous, 1 hour for every 52 hours work. So people have to work a little bit longer to earn that sick leave. So we are seeing rates of accrual differ in the various states. And also some employers want the employees to accrue overtime, so as they work, but states do allow generally employers to give a lump sum or to front load that time and let people take it up front. And there's some benefits that come along with that for employers. That means often employers, you know, they're relieved of the administrative burden of tracking when people are accruing it, but you run into a problem perhaps where you front load and you give an employee all of their sick leave on January 1st. They take the first week of January off because they're sick, and then they leave, and you will have paid them for that nice little vacation because you front loaded it. But there are some benefits, and so employers have to weigh how they deal with that. Most states, or I think all states, have a cap on the accrual. So employees, because many of these systems accrue time as employees work, if they work overtime, they accrue more that particular week. They could hit 30 or 40 hours of sick time accrued pretty quickly. So the state laws have put a cap in many instances on how much they can accrue. And then once they have that accrued, the states talk about carrying over to the next year. So in most cases, they can carry it over to the next year, but then they don't accrue anything in their sick leave bank until they have used a little bit of that. So these are, again, all important things to be paying attention to with whatever state you're in. Does it have a sick leave program? What's the cap? Can you carry it over? Is it paid out when they leave? Is it paid or unpaid as they use it? That's another differentiating factor among the states and even within a state. So for Massachusetts, for example, if you have 10 employees or 9 employees, you do not have to pay the sick leave. You have to give them protected time off as someone who uses his sick leave, but you don't have to pay them. Then when you hit 11 or more employees in Massachusetts, you do have to pay them. And then another, because some of these sick leave programs, or many of them, also say you can use your sick leave to care for a sick family member, the question of what is a family member, it may be different from state to state. Some say it's children and parents. Some have, Massachusetts has parent of a spouse, parent of a spouse, and some may have domestic partner. That is a definition you're going to want to make sure you understand, so that if somebody comes to you and says, I have to take a couple of sick days for this reason, you have an understanding whether that the sick law that you are dealing with covers that family relationship. So just a quick overview of some of the, I believe this is it at the moment, although it's changing rapidly, the list of states that currently have some form of a sick leave law. Maine, I'll get to in a second, has one on the books, but it doesn't take effect for a little bit. And then there's dozens of cities, towns, and counties that are getting in on the action because either their state hasn't, I think Pittsburgh, for example, has something because Pennsylvania hasn't imposed any sick leave law, but there's been a judgment that they do want to offer it to their employees or within their territories. So constantly changing and updating and important to pay attention to. For example, I wouldn't necessarily know. I would look on the book and say, hey, Pennsylvania has nothing, but I need to know exactly where the operations are. I would need to figure out if I have an employee in a county where they have sick leave law, even if I don't have a physical office space there, how is that going to work? So these are the types of questions you need to really drill down on when you have employees in different states. And we have we get questions all the time. We want to do something nice. One of our employees, they've been here for a really long time. They want to retire or sort of cut back and in advance of retirement, and they're going to move to West Virginia to be closer to their grandchildren. We're going to let them work remotely. You're going to need to pay attention. What kinds of leave laws are there? Does it apply to somebody who's just a single person in that state? And what protections, what the range of protections they have. So this list a good resource, but not the end of the questions, I think. Then I talked a little bit the sick leave accruals and what the caps are. And then I mentioned Maine. So Maine is the first state to come up with a leave law that will cover not just sick leave, but time off for any reason. So effective January 2021, the state of Maine will require paid time off for any reason, so vacation or sick, other reasons, if there's for employers who have more than 10 employees working more than 120 hours per year. So if they are seasonal employees, that might not qualify, but if you have a headcount of more than 10 employees, this law is going to be important to you. And employees will earn 1 hour of paid leave for every 40 hours worked. So it's not necessarily, I think the mainstream has been around 30, so we're looking at 40 hours for Maine with a maximum accrual of 40 hours a year. They begin accruing immediately when the law takes effect, but also upon hire. If someone is newly hired, it begins accruing immediately, or will begin accruing immediately, and they can't use it for 120 days. So that's another standard thing. Massachusetts, you have to wait 90 days. So there you have to pay attention to when, if this person is accruing it, it's showing up on their pay stub or in their account, when can they actually start taking it? And then the question in Maine is going to be, it only requires that the employee give reasonable notice that they want to use it, and that is not currently defined. So as Jim said, a lot of these, the laws are put on the books and then they try to figure it all out. What's happening right now, as there's been over the fall, I know there were listening sessions in Maine going around asking employers for feedback or giving them a little bit of pre-education about what this law could mean and how it could impact them, so that they can come up with some regulations and some guidelines on how this is going to play out. Because there's going to need to be some additional details put out by the state of Maine to help employers understand, is 36 hours reasonable notice of a planned absence, or does it, if they know about it, are they supposed to give 7, 10, whatever days? Yes?
Is that more than 10 employees in Maine or 10 employees the whole company?
And so the question is that more than 10 employees in Maine or in the company? And I actually don't know that it just says 10 employees at the moment. So that may be one of those things that needs to get worked out. And I'm not sure that it says yet. Okay. Okay, so Maine will be a sort of on the threshold of new things, and we'll see how that plays out. So parental leave. This can get tricky fast, right? Sick leave, you're dealing with a pretty finite amount of time for some pretty finite purposes, not necessarily a significant disruption, and hopefully they use it up and they move on. You move on. But parental leave and paid family leave have much more of an impact in the workplace. And so states are really trying to grapple with what is the best formula that they want to use. And I've just put down here a couple of the sort of the themes or the types of programs that we're seeing, or the types of state laws that we're seeing. And they really, they run the gamut. So there are some state laws that address parental leave by just saying, if you're a pregnant employee, you're going to get the same benefits as you need to get the same benefits as a disabled person would get. There are some states that say mothers can use sick time. Nothing about fathers in that equation. There are some that say mothers use unpaid leave for the length of a documented disability, so in New Hampshire. There are some that say that require employer-offered disability insurance to cover maternity leave. So you see we're getting more and more protections. In that case, employer-offered disability insurance would at least provide some partial wage replacement if somebody goes on maternity leave. Then there are a number of states that are offering unpaid leave for all eligible parents. So Disability, obviously, is the person who gives birth. The father or an adoptive parent wouldn't necessarily have any reason to claim disability leave, so that's a much narrower scope of the population who can take advantage of those types of leaves. But then there are states who are more generous and offering unpaid leave for all eligible parents. That only goes so far because just economically speaking, it's going to be a lot harder for everybody who is qualified to actually be able to afford to take that type of a leave. And then finally, we have the states that are really doing groundbreaking and offering paid leave for all eligible parents. So, you could have operations in multiple states, and you could have something along those spectrum, many operations along that spectrum, and you'll have to figure out how are we going to manage that. And we'll get to some thoughts on that at the end. So just to give you an idea of some of the states that allow disability leave for pregnancy-related conditions, New Hampshire, the length of the leave is based on the employee's physical disability due to pregnancy, childbirth, or medical conditions. It's unpaid. It could be indefinite if they continue to have doctor's notes supporting that leave. California, Rhode Island, and a number of other states have various types of required disability benefits programs. New York, New Jersey, etc. So then the states that are offering unpaid parental leave. And Massachusetts is an example of this at the moment. Massachusetts has its Parental Leave Act. And under that law, an employee who has been full-time employee for 3 months, male or female, is entitled to 8 weeks of unpaid job-protected leave for the purpose of birth of a child or adoption. So that does cover male and female adoptive parents. The law specifically says that adoptive parents are entitled to the same benefits as birth parents. And the law also says that it understands there may be situations where an employer is willing to give more time than that, but if you do give more time than the 8 weeks that's required, you have to let the employee know if that could jeopardize their job at all, because the 8 weeks is what is guaranteed if the employee can afford to take that long, because it is not at this point a paid entitlement. California has many laws in this area, and that could be its own presentation all by itself, the way that all the California laws interrelate. But there is a parental leave component as they are there for bonding. And then, as I mentioned, so these are unpaid leaves. As I mentioned, many states are starting to move into the paid parental leave domain, and that's really is part of the paid family leave program. So just to jump to that for a minute. So, as you know, FMLA, the federal law, offers unpaid leave for employers it covers employers that have 50 or more employees within a 75-mile radius. So it may very well be that if you have operations in multiple states, if you have 60 employees in New Hampshire, FMLA may cover those employees. But if you have 10 in Maryland and 15 in Florida, it may not, you are not required to offer FMLA to those other operations. So that's going to be a question that the employer has to deal with. What do we do if one of our sites, the employees would be covered by FMLA and others they would not? So it does offer unpaid leave, job protected leave, having to return the employee to the same position after up to 12 weeks of leave to care for a family member or to bond with a child, or for the purpose of giving birth, bonding with a child, adoption, and caring for family members. So again, just as I did with the parental leave, there's a real range of the types of paid or of family leave and family and medical leave laws that are emerging. There's several state variations. So some of the states have said, okay, we understand what FMLA does, and we want to be a little bit more generous, but we're going to expand it in this way just for public employees, but not including private employees in however they choose to expand it. And they can choose to expand FMLA in a number of ways, right? We know what the purposes are to bonding or have a child or adopt or care for a family member. But they may expand either the size of the employer unit that these benefits are available to, or they may say, we're giving you more weeks. So there's a number of tweaks that they can make to the FMLA that they have made to the FMLA. But some states that are doing this are saying, no, we're only doing this for our public employees, and private employers are going to have to make their own decisions. So Alaska, Arkansas, and Florida are in that category. And then there are those states that expand FMLA type protections to smaller employers, to more family members. So there's a relatively small group of family members who are defined in the FMLA that employee can say, I need to take time to go care for my spouse, but doesn't cover a sibling, for example. And so some states have said, if you need to go take time off to care for a sibling with a serious health condition, we will expand our protections and we will let you do that. So there are some states that are expanding, that are saying if you have 30 employees, for example, we will say that you can take that time off. If you're caring for a sibling or somebody else that's not covered by the FMLA, we may allow you to do that. Or saying it's not just 12 weeks, it's actually a longer period of time. So there's a number of states that are doing that as well. But again, unpaid. And then we move into the realm of the states that are saying there's paid employee leave through disability programs. So Rhode Island and New York have that sort of an arrangement. So New York, for example, has a state mandated disability program where employers have to offer disability insurance through a disability insurance carrier to their employees. And then as of, I think, January 2018, New York employers also have to have this family medical leave insurance for family members, to care for a family member. And then finally, we have the states that are beginning to offer paid family leave. And so Massachusetts is sort of on the beginning, or I guess maybe along the path of offering that, but the benefits are not available yet. We'll talk about that in a minute. In fact, we'll talk about it right now. Okay, so Massachusetts will offer paid family and medical leave. The law passed a couple years ago, but it was pushed off for a couple of months after its initial due date, commencement date, and it was supposed to be, I think, July 1st, 2019, that employers had to start collecting contributions from employee paychecks, and potentially employers had to contribute themselves. So the way this system in Massachusetts is going to work is that they're going to spend the next now 15 months. It was October, the initial date of collection was July, they moved it to October 1st. So they're going to spend 15 months collecting contributions from employees and employers, building up this trust fund so that in January 2021 or July 2021, when various benefits become available, there will be a source of funds to pay for those benefits. So now we're in the collection phase. We got through the education notice, letting everybody know about this, giving them information about this. Now the October through December, the employers were supposed to collect for the 1 quarter, that first quarter, and the first deposits into the state trust fund will be happening in the next couple of weeks. So we're in this build up the trust fund phase, and then some benefits become available over time. So this is the Paid Family Medical Leave Act law that took effect in Massachusetts. It created a new agency, so now there's the Department of Family and Medical Leave, and let me tell you, it's a small but mighty group. They have been very, very busy. I had one client who sent a question. They are a regional school district, and but they're a charter school, and so there's been some confusion. If you're a charter school, you have to pay into the system, but if you're a regional school, you don't have to pay into the system. And they said, well, we're both. We're a regional charter school. What do we do? And they got an answer at 10:30 at night from one of the people working for the state agency. So they are definitely on the ball. They've done a lot of education, putting out a lot of guidance, and which is great for employers trying to figure it out. But I have to say they have not been totally consistent in everything they've done, so they've caused a little bit of alarm there as well. So we do have regulations that took effect in June of 2019. They will probably be tweaked. There are some things that still don't make a lot of sense. So we will continue to watch that. But the important thing is that the Paid Family Medical Leave Act of Massachusetts is going to rely heavily on the Massachusetts unemployment system. So there's a lot of education that employers need to do about what that means, and some things that are somewhat unexpected. If you think, I'm an employer, I pay this employee their wages, and I'm going to have to take a percentage of those wages and send them to the state, that would be a reasonable thing to think. But under the unemployment law in Massachusetts, wages also includes whatever contributions go into the 401k. So now you have to look at a bigger amount and figure out what you're supposed to be contributing to the state. So there are some things that we're going to have to still be tweaking as we move forward to figure out, how does the fact that this relies on an unemployment statute, and if the unemployment statute in Massachusetts should state change, we're going to have to figure out how that impacts this law. But employers are getting the hang of it. They're making deductions from employee wages, and then they're about to make the contribution to the state at the end of January. So what coverage is there under Massachusetts? And this may be, for those of you with Massachusetts operations, a little bit of poor refresher, because I know that it was in the June through October timeframe was very stressful for employers trying to figure out, does this apply to us? Do we need to do this? What happens if we have independent contractors? What happens if we're a New Hampshire employer and we happen to have one employee who lives in Massachusetts, works remotely in Massachusetts? Does this apply to us? And the answer to that, by the way, would be yes. What happens if we have New Hampshire employer with some people who live in Massachusetts but don't do any work there and only come and do their work in New Hampshire? And it looks like the answer to that is you don't need to worry about it. So if you are in that category, you've escaped a bullet for the time being. So this applies to most Massachusetts employers and Massachusetts, what's called covered business entities. And what this is attempting to get is not just the employers that are set up as that they have all employees, but also employers that really rely on a heavy stream of independent contractors. And so what they were trying to do is say, if more than 50% of your workforce is made up of 1099 employee or 1099 workers, you have to make sure that you're treating them as part of your workforce and collecting money from them and giving them all the notices. So that is an area I don't want to go into too much depth because it does get complicated, but it is this is an effort, yet another effort by the state of Massachusetts to make sure that employers are taking a very careful look at whether people are properly classified as independent contractors or employees. So this is an area that if an employer says, I don't need to worry about that person, they're a contractor, if they do it wrong, they're not only going to now have problems with unemployment and workers' comp and taxes, the Department of Revenue, but now they may have violated this law as well if they didn't treat somebody as an employee when they basically should have been. So most Massachusetts people are going to be covered by this law. Some contractors will be covered by this law, and then self-employed people can opt in, so they can voluntarily say, hey, I want to send a portion of my paycheck to the state, because then if I need to take weeks off to care for myself or have a child or care for a parent, I now have at least some form of wage replacement. So some self-employed individuals may opt into this. And former employees, which is kind of a big deal, right? Because you think once the employee is off your payroll, you don't have to worry about them anymore. Well, if they are a former employee who is left within the last 26 weeks, they can make a claim against their paid leave. Okay, Massachusetts covered workers. I just very briefly on this. We've had a lot of questions about. I have a small shop in Massachusetts, and I hire contractors. One of them lives in Oregon, one lives in Florida. What do I do about that? I'm a Massachusetts employer, but they work elsewhere. Well, this is going to be just covering the people who live in Massachusetts. So when this law first came out, the understanding was had cast a very wide net. It was not only trying to get contributions from employees who worked in Massachusetts, but maybe employees who lived outside Massachusetts and remoted in or came here once in a while. And we also thought it was intended to cover anybody who did independent contractor work for this company if there were more than 50% of the workforce. So when this first came out, we really thought, wow, the state of Massachusetts is really trying to get as much money in the door by saying all these people are covered. Over time, we've seen that really narrow. So now, fundamentally, employers just have to worry about who their employees are, if that are working, that their services are localized in Massachusetts. But also outside companies, so New Hampshire companies, Maine companies, who have employees working in Massachusetts, if their services are localized in Massachusetts, are going to have to worry about that. And then, as I said, self-employed individuals may opt in as long as they have more than $4,700 worth of earning. And you can't just say, oh my gosh, I just got the diagnosis from my doctor, I'm self-employed, I'm going to need some treatment, let me send in a check of contributions to the state and now I'm going to get 12 weeks or 20 weeks of paid leave. No, they have to have contributed at least 2 out of the last 4 quarters. So they're trying to cut down on abuse of that. And then former employees, again, they will be able to make a claim for this paid leave through this paid leave program if they've left your employment within the past 26 weeks. So who pays into it? So as I've said, the employees are going to have to pay, but also employers may have to pay. And what the state is collecting now is 0.75% of gross wages and other payments made to employees. So as I said earlier, you don't just look at what their paycheck is, you may look at other contributions, other wages, other compensation you pay to them, including 401k, up to the new number of 137,700. So for each employee, the employers will be collecting a certain amount, but they stop after they hit the Social Security number. And this, you can probably see it better in your handout, but this talks about the way that this is all broken down. Depending on the size of the employer, it may be that only the employee chips in to the state. And every check that gets sent in is going to get distributed between a medical leave pool and a family leave. So the money is going to be distributed that way so that there is funding for both types of leaves. And depending on the size of the employer, an employee may be the only one contributing. If the employer is large enough, then the employer is also going to have to kick in. So there may be times where the state doesn't get a full amount of what it's looking for because the employer is too small. The employee is never going to have to pay more than 38 cents of every $100 of wages. That's going to be the maximum what the employee does. But if the employer is large enough, then the employer is also going to have to kick in to, again, grow up that trust fund so that we have funds to pay for the leave. So we have, again, I talked about opting in, self-employed people can opt in, and then who can opt out? We get that a lot. We're a small employer, people don't want to give up any more wages, they get hit enough with taxes. Why should they have to do this? Or I'm a New Hampshire employer, I have one person sitting at their house in Massachusetts, yes, that's where they're working, but I'm being nice and I didn't sign up for this to kick into the Massachusetts system. Can't we let that person, not participate? Can't they opt out? And the answer is likely not. The only way that they can opt out is if the employer gets an exemption, and the way to get an exemption is to make sure that you're offering a private plan that is just as generous as the state. So it's going to be very few exceptions. And I don't know what the latest stats are, but when they were first starting out, there were exemptions being given, but there were very few private plans out there. Now they've developed more, so I expect that more employers are coming up and saying, you know what, this is a great program. I understand we have to comply with it. It's good for employee morale and keeping employees engaged and retention, but we don't want to take money out of our employee paychecks and send yet another check to the state. So we're going to do this ourselves. We also potentially have a little bit more control by having a private plan, because the way that the state is going to operate is once we collect all this money and the state goes, starts offering these benefits, employees will make a claim to the state, and the state will get the medical documentation saying this person has this illness and needs time off, and the state will grant that, keeping the employer pretty much out of the loop. So employers who are offering their own private plans will have more control over at least some additional information about what actually is going on. So we are seeing employers provide for having their own plan. And then there's also a number of employers that are already generous and are already offering paid leave. They might not be offering paid leave for all of the same types of purposes. So you may have a company that already offers a parental leave or a maternity leave program. And employers can say, we want to opt out of paying for the medical leave, the parental leave component of this, the employee medical leave, but we're not going to opt out of the family leave, because our current policy doesn't pay an employee to go care for their grandparent. So the employers can make a distinction and say, we have a plan, it's very generous, we're going to continue to do it, but we're not going to pay into the state for duplicative coverage. However, we're going to pay into the state for this other coverage. So it's important to look at what your current plans are and figure out, do you want to opt in, do you want to try to opt out of the Massachusetts coverage? It's important also to know how much we're talking about here, right? So 12 weeks of paid family leave will be covered in Massachusetts, will be given in Massachusetts. So that includes bonding with a child, caring for a family member's serious health condition, and a military qualifying exigency. So for those of you who are big enough to be familiar to have to implement the Family Medical Leave Act, you'll see a lot of the same terminology. So under FMLA, you have your employee's own serious health condition, you have a family member's serious health condition, you have military qualifying exigency. So when somebody is called to active duty and the family members have to figure out, let's get our wills done, let's get the child care set up for when this military member is gone. Those are the types of things that may qualify. And then 26 weeks to care for a military service member. So again, that tracks what the FMLA offers as well. But the total leave in a benefit year cannot exceed 26 weeks, but it can be intermittent, reduced hour leave, just as under the FMLA, where someone can say, I have to have treatment every morning, chemo, so I'm going to come in at 10 o'clock every morning. And so I want that, the first 2 hours of every day to be intermittent. So the same thing will apply in Massachusetts. However, this is not all rolling out at the same time. We have January 2021 when all types of leave except to care for a family member will become available. So bonding leave, having a child, adopting a child, that sort of leave, military caregiver leave will take effect in January 2021. And then they just need more time to build up that caring for a family member. So that's when July 2021 is when those benefits will become available. As in many states, this is not full wage replacement. These programs are not making it necessarily a coup for people to take leave. The purpose is to provide some wage replacement to help them through, but not necessarily incentivize people to try to take this leave. So it's wage replacement in Massachusetts right now. It's going to be up to $850 a week. I know New York, I think it's slightly less than that. So states have a formula that are putting these laws in place, have a formula about how much they are going to allow people to take. I know Maine had a proposal a couple of years ago, a similar idea. You look at the average weekly wage in the state and you say that's a percentage of that is what we're going to allow people to get up to. And some people may not hit that, but some people may be well above. They may bring home way more than $850 a week, but this is what they're going to be capped at. The other benefit, in addition to wage replacement, is continuation of health insurance. That's similar to the Family Medical Leave Act, where employees continue to pay their premiums, but the employer carries them on their health insurance under FMLA. And then returning from leave, again, these state laws, Massachusetts, I'm using it as an example this morning, but other states that are getting on this bandwagon are also saying this is job protected leave. Returning the employees to the same or equivalent job is a critical part of letting them take the leave. Yes, it's important that you pay them, but it's equally important that when they come back, they're not demoted, they have a place to go. But you can ask that they show that they are fit to return to duty. So a letter from their doctor releasing them to work is a perfectly fine thing to ask for, just as under the FMLA. And then, as under the FMLA and in other states, retaliation against somebody that asks to take this leave or does take this leave, retaliation is prohibited. In Massachusetts, there's a little bit of a red flag for employers that may find its way into other states. In Massachusetts, if an employee returns from leave, and it might be 6 months, there's a period of time that if they suffer some sort of negative action in their employment, it is presumed that you have retaliated against them for taking this leave. So it is going to be very important for employers who are managing this, and we're talking about managing leaves. So a lot of that is giving upfront notice. A lot of it is tracking the leave, then making sure that people are getting the right amount of leave, and then being sure that they're returned to their job. Well, in Massachusetts and likely in states in the future, there's then going to be a period of time afterwards where you're going to have to work closely with management to make sure that, yeah, maybe they came back and they're not focused on their job and there are legitimate performance issues, but we've got to be very, very careful about tracking that and making sure there's documentation, making sure that you're not nitpicking or micromanaging somebody, because that it used to be, retaliation looked at, did you treat them differently? Did you isolate them? Did you take some sort of affirmative action or, exclude them? And that was retaliation. In Massachusetts, they're going to look and see, did something negative happen in their work, relationship, and that is presumed retaliation. So be careful and understand the obligation continues beyond when they come back. There's a lot of penalties, and again, this is not unusual, both to have notice penalties, right? There's going to be maybe handbook or posters or notices. In Massachusetts, you're supposed to get a notice, give a notice to employees and have them sign it and give it back to you. So failing to do that can lead to monetary penalties. Not making the contributions to the state obviously has penalties, and then there's also, because this is a tax, there's tax evasion penalties in Massachusetts. But again, as we see more and more of these leave laws in various states being modeled on one another, harkening back to the sick leave, you see very similar trends in how these states are rolling these out. So states that are looking at these are looking at what has Massachusetts done, what has California done, what has New York done, having these types of penalties built into a state system is probably not going to be surprising. Just quickly to wrap up the Massachusetts part, 3 of the deadlines are already passed, and we've got some more coming up. But we have all of 2020 for employers to really get their act in gear and make sure that they're ready to roll out this paid leave program, and part of it is going to be educating the managers about what this is going to require, because it is going to have an impact on who's at work and how long are they out and what can you ask and what can you expect when they come back. So we have a year to get that in order. I just included a couple of resources that have been helpful for us. So very quickly, Maine does have and has had for a while a family and medical leave law. And I talked earlier about, we have the Family Medical Leave Act, the Federal Family Medical Leave Act, which has a threshold of 50 employees within a 75-mile radius. That's how you know if the employer is covered. Maine's law is extended. It covers any private employers with 15 or more employees, and public employers of a certain size, a larger size. Now, some of the differences between Maine, the state law, and the federal law are not only that it now covers more employers, but it covers more employees within those employers. So what I mean by that is, in order for somebody in Maine to be covered by the Maine Family Medical Leave Requirements Act, they have to have been employed for 12 consecutive months. But unlike the FMLA, there is no minimum number of hours they need to have worked. So you have 1,250 hours under the federal law. There's not a requirement like that in Maine. So you will have part-time employees who could be eligible if they have a proper reason and they've worked 12 consecutive months. Now, there are some other differences. Some benefit the employer, some benefit the employee. There is greater coverage under the Maine law, so people can take leave to care for domestic partners. And I think there's a couple of other categories of people that could be, the subject, someone who has a serious health condition, and the employee could say, I need to take care of them. So there's a little bit broader. But from the employer's perspective, it's a little bit better because it's not the 12 weeks in a benefit year or in a year that the Family Medical Leave Act, the federal FMLA, has. It's up to 10 weeks in a 2-year period. So that's a little bit better for the employers. The purposes under Maine law are very similar, birth or adoption, an employee's own health condition, or to care for a family member, but it does include also organ donation, or for the death of a family member on active duty. So not just service caregiver leave for a service member, but also for the death of a family member on active duty. And then just as under FMLA, intermittent leave is allowed. So as Jim mentioned, there have been multiple efforts over the past several years in New Hampshire to bring this to the state. And there's been many twists and turns. There's been a lot of competing proposals. There have been a lot of concerns raised about, well, this is a tax, this isn't solvent, this is going to hurt employers. There's been a lot of proposals. Just to cover a couple of them, there's one that was introduced to create a voluntary paid family leave insurance program. So not a tax, they say, but employers can opt in, so the voluntary leave. And then in November, there was sort of tweaking of an earlier bill to take care of some of the concerns of that. So now that bill has moved a little bit further down the path. That would require, as in Massachusetts, you require a certain percentage to be paid into the state. So that was to withhold 0.5% of the employee's pay. Keep in mind, Massachusetts is 0.75%, and this would provide benefits up to 60% of wages. So, there are other options. There are a lot of folks working on this, and we'll hopefully may see progress one way or the other in 2020, so employers can have some certainty. So I want to just spend a couple minutes talking about managing all these policies. Obviously, I've given you a lot of information about sort of the minutia of what some of these state laws cover, and also some general themes about what you need to be looking for. But if you're faced with a situation where you have just one state to worry about, great, that is awesome. It doesn't happen a lot in what we see. There are just, with the mobility of the workforce and the number of companies that have offices in other locations, we are really seeing a significant amount of attention being focused by human resources and finance folks trying to figure out, what do we have to do? What might we do? What will we have to do in the future? And really trying to figure out a policy that makes sense for them, that is compliant with the law, and something that you're not going to have to change every 6 months. So we've been working with a lot of employers to try to figure all that out, our own firm included, really trying to look and say, okay, we have a New Hampshire office and a Massachusetts office. How do we bring this all together? So just want to talk briefly about the types of areas you're going to have to be focused on. There's first tracking employee eligibility. You know, what laws apply to us in this particular state? How much does this employee have available to use? And are they using it for the right purpose, right? So it's all the tracking stuff. How are you, what have they accrued? What are they using? Are they done? And then, you know, what happens when they come back? Then there's coordinating with Family Medical Leave Act. I mean, I think a lot of employers kind of say, okay, this is how I deal with FMLA, and this is how I deal with the state. But often these laws will say, and policies that employers put out say, these run concurrently. So you have to remember, if you want to have the leave check the box under both laws, you have to do what is required under both laws. And I've had employers sort of forget to send the notice of rights and responsibilities under the FMLA and forget to send the designation notice under the FMLA. And they then try to scramble at the end and say, well, we said it ran concurrently and we got all that information and we did what we needed to do under the state. And just got to hope that the employee doesn't say, oh, but I now am entitled to my 12 weeks of FMLA. So you need to be watching compliance under both laws. Then coordinating with other leaves, coordinating with your existing policies, and then the big one is coordinating across state lines. So just a couple of thoughts on each of those. Tracking eligibility, you want to be making sure that you have a system in place to make sure you've given the right notice. You know, have you done what the state law requires? Some, as in Massachusetts, required employers to give a written form that the employee had to sign and send back. And if the employee didn't want to sign and send that back that form, the employee had to sign a form saying that they weren't going to sign and send it back. And if that didn't happen, then the employer was supposed to take, write something showing all the efforts that they've done to get this information in the hands of the employee. So are you doing what the state law requires to give your employees notice? Handbooks, intranets, posters, handwritten, signed forms. Are you keeping track of that? Are you holding on to those acknowledgement forms as long as you need to? Then the tracking which employees are eligible, right? You're not going to have everybody in your workforce eligible at the same time often. Under FMLA, people have to work 12 months and 1,250 hours. So and under some state laws, it's going to take a while for people to get eligible. Even if they're working in a cube next to somebody that just went out for this particular reason, they may not be allowed to do that. How much has each employee actually accrued? And how much have they used? And are managers paying attention? I mean, how many managers, the no good deed goes unpunished? Oh, sure, they didn't come in today, but we're not going to worry about it. Well, it takes a long time to use up intermittent leave. So if managers are giving people special dispensation and you don't have to come in, or I'm not going to track it, or don't worry about it, it's going to take even longer and potentially cause more of a disruption. So making sure that you're working with your managers to be tracking on the ground the leave that these people are taking. And then any evidence of abuse or misuse, because that is something that can be punished. But you've got to be very careful when you do that. So you do want to make sure that you're getting whatever information you need to know that somebody is abusing or misusing time. So I mentioned coordinating with FMLA. There will be people who qualify under some leaves and not under others. Right now, we have in Massachusetts, for example, we have the FMLA, but we have also the unpaid parental leave. Unpaid parental leave is for anybody who has been full-time for 3 months. So they get parental leave even before they are entitled to Family Medical Leave Act, which requires that they have been there for a year. So you will need to make sure in which bucket does this person fall, or is there an overlap and they might fall in both. Is the employee eligible for FMLA because of the number of hours they've worked, for example, or because of the reason that they want to take the leave? Is the reason for the leave covered? Does your policy notify employees that the leaves will run at the same time? So if you take leave for this reason, it's also going to check the box for this reason. You want, as I mentioned, want to make sure you've given the forms and the notice, and you want to make sure that the job protections are the same. Sometimes they say they have to go to the same job. Sometimes they can go to the same or an equivalent job. Sometimes you can readjust an employee or reassign an employee for under intermittent leave if you know that they're going to have planned intermittent leave under the FMLA. you can reassign an employee to a different position that accommodates that better. That might not be allowed under state law. So you're going to want to make sure that you are, you know what the requirements are of each and how it's going to affect a particular person in your workplace. So it is definitely not a one-size-fits-all. It is a case-by-case situation, and you know, you really need to be paying attention. Just because I did it last week for this person doesn't mean it's going to look exactly the same for this other person. Coordinating with other leaves, and I just threw up a couple here. Short-term disability, you know, many employers have that as an option, and you need to make sure that you are also tracking if you're expecting this to run against family medical leave. I did put workers' comp, but that's obviously one that you need to be paying close attention to as well. Domestic violence leave and sick leave. If you're having a paid family leave or an unpaid family leave situation, does any of that time take off against domestic violence leave or sick leave? Coordinating with existing policies. I spoke about some employers having company paid policies already. And what is becoming very clear is how difficult that is going to be or could be if you have operations in multiple states. Because you may say, we're being good to everybody, this is what we're giving. But what happens if now Massachusetts gives up to 26 weeks if a mother is disabled leading up to the birth of a child and then takes 12 weeks for bonding leave? So she gets 26 weeks of paid leave. How does that match up with your policy that says we pay X amount of weeks for parental leave? So, and then what happens if that's what happens in Massachusetts, but your New Hampshire employees don't get as much? So you're going to need to really pay attention. How do we marry our what we're trying to do, the right thing in our workplace, with what the state requires us to do, and especially if we have multiple states that we're dealing with. The other part of it is, if somebody is allowed to collect benefits from a state program, for example, in New York and in Massachusetts, they will be able to. They collect benefits. They make a claim under this paid family leave program. They make a claim to the state. The state pays them benefits. It should be very clear that they're not going to then also be allowed to collect your short-term disability policy or your paid leave policy to get more than they would have gotten in their regular paycheck. So you're going to want to have some coordination of benefits. You know, how much will the state pay versus how much will we pay? You also need to be thinking about, if there's an opportunity where an employer has a generous program, can it opt out of paying for these state benefits or making their employees pay for these state benefits? So, and as I mentioned earlier, there might be an opportunity to split. The employer can opt out of just a piece of it, send some money to pay for that, but the rest of it they'll handle in-house through their own policies. And then what happens if the employer has a very generous policy and says, we're going to cover it, you're going to get more with us than you would with the state? There is a possibility for the employer to then go back to the state if the employer has to pay into the state anyway because they can't opt out. They might be able to get some money back from the state. So the employer pays the employee their entire, you know, what's due under the employer's policy, and then they can go recover a little bit back from the state. So it is, again, there's a lot to coordinate with existing policies. And then it becomes even more hairy across state lines, right? So you need to know what the laws are in the different states that you operate in. And you need to understand, if I have one employee there, what does that mean? How will you reconcile any differences that you find? How will you track those differences, and how will you communicate those differences are all things that I know will keep people up at night. You know, honestly, there's a lot going on. And if you don't treat somebody fairly under these laws, there could be wage issues and there could be discrimination issues. And there certainly could be morale issues in the workplace. How come those people in Massachusetts get so much time off, more time off than I do? And why is the person that does the same job as me in this other state able not to be there for so long, and I get all the work? So there's a lot to manage here. But there's a couple of options. One is to follow the law that's the most conservative and favorable to the employees and apply it across the entire company. that's not always going to be possible, right? Because in Massachusetts, employees are paying into the state. New Hampshire is not. So how can you manage that? That might not be possible. But if you have laws that are different in each state, and you can say, you know what, for example, the Massachusetts sick leave law gives Massachusetts employees 5 days of sick leave. New Hampshire doesn't have that. But many employers say if we have employees in both, we're going to give employees in both states the same amount of leave, right? Paid leave law is going to be, I think, a little bit different. It's upping the game a lot. But paid leave and sick leave is something you could certainly say, yeah, it's going to cost us, but it's the right thing to do. And maybe someday it will be in New Hampshire and you'll be ahead of the game. So, but it's a retention tool, it's an engagement tool. Or you can follow the most favorable law in most situations. For example, saying we'll give everybody in the company 5 days of sick time and you accrue it 1 hour for every 30 hours worked. And you can take it for these reasons, which include taking your mother-in-law to the podiatrist. But there's a couple places where we have to separate out the state law. So for example, if you take paid family leave under Massachusetts, people in New Hampshire are not going to get that. And one way to explain that from a morale perspective is New Hampshire employees, you didn't have to pay into the system. Massachusetts did, and that's why they get it. Or you can treat your employees in different states according just to the law of that state. So this is what our Massachusetts employees get, this is what our Maine employees get, this is what our Florida employees get, and that's it. And then it's the question about how do you communicate that. Communicating those differences can be tricky. If you put all of your various policies in one handbook and everybody has access to that, you may have a lot of people, why is that happening in that state and not for me? Why do they get this and I don't? So employers do take a number of different approaches to this. They may put everything in the handbook and say, this is for Massachusetts employees, this is for New Hampshire employees. And hopefully you have enough that balances out that employees in New Hampshire say, oh, well, we can do, first responder leave, and Massachusetts doesn't have that. But, that doesn't always work. Sometimes employers say, here's our basic policies, and we have an appendix at the back, and we'll give you your state-specific appendix, right? And say, this is what Massachusetts employees get, this is what New Hampshire employees get, and the employees don't necessarily see the appendix from the other states. Or it's just a separate handbook for each state. I think the second option is the one that I've seen more of because it's kind of a headache to have a separate handbook for each state. But then this is the book I pick up when an employee from this state calls me, and this is all I need to know, and all they need to know. So just to wrap up, we definitely are seeing an evolution towards employee-friendly, family-friendly, that giving time off, and it increases for a whole bunch of different reasons. It increases workplace satisfaction, and there's a lot to be said for that. The problem is the uncertainty for employers, the difficulty in administration for employers. There's just an awful lot going on. There's an awful lot to manage, and you've got to be paying attention to the developments. I think I could probably spend about 45 minutes every morning looking through all my alerts that I have set up to, paid sick leave and paid family law, and just making sure that I at least, have a passing familiarity with, Idaho just, had some big development in this area. So at least it rings a bell with me. I'm not going to know the details, but there's an awful lot to keep up with, and there's a lot of really good free resources to do that with. But it's definitely adding a whole nother number of hours to your job requirements to keep up with those. But you just want to make sure that the bottom line is when you have those federal and state law or state laws that conflict with one another, that you are making sure that the employee at issue, you are dealing with the correct set of laws. And if you have an option of a federal law or a state law, you are making sure to follow the more generous law, because that is what the states will require you to do. And just stay tuned for more changes. I'm sure by May, or if any of you are coming, and I'm sure Jim has this on the agenda, that there will be some more states on the list of sick leave law and possibly even paid family leave. So I am available for questions, but it's a nice day, and I know people probably want to get out and get busy. So, but thank you for your attention. And again, if any questions, happy to answer them.
Thank
Good. All right, good. Thank you.